Hello, everyone, and welcome to Uncivil Law. I am a licensed attorney, and for today's video, I'd like to talk about the Child Online Privacy Protection Act, better known as COPPA. There's been quite a lot of information and, dare I say, misinformation spread around this topic on YouTube recently. And much of that misinformation, in my view, has come directly from YouTube themselves. Both YouTube and the FTC have said that the Child Online Privacy Protection Act applies to individual channel creators. They have said that you must flag your video as targeted to kids if it appeals to children under the age of 13. They say that if you tag a video as not belonging to kids and it does belong to kids, you can be fined up to $42,000 per violation, and your channel may even be ordered to be taken down by a governmental entity. And this all sounds very scary, and in my view, has been designed to sound scary. It has been designed to sound scary so that it will put fear into people so that they will behave a certain way. And people have started to behave that way. People have removed content from their websites, they have deleted videos, and some people are even deleting their channels. They're so afraid. But the question is, does the Child Online Privacy Protection Act, does COPPA, actually apply to individualized channel creators? Or is YouTube and the FTC just simply blowing smoke? To answer that question, let's look at the relevant statutes. Of course, although I am an attorney, I am not your attorney, so I cannot give individualized legal advice as it applies to you. But what I can do is I can read a statute and I can explain what it means. So here is what the statutes say, and let's go on with this. First, let's start with YouTube's website. YouTube has a page on this determining if your content is made for kids. And it says, regardless of your location, we require you to tell us whether or not your videos are made for kids. It's YouTube doing the requirement. That's important to note. We are making these changes according to an agreement with the FTC. Why is YouTube doing this? Because they've reached an agreement with the FTC. YouTube and the FTC have signed an agreement. So YouTube is doing this because they've made an agreement. Well, what is that agreement? The agreement in question comes as a result of this case. In the United States District Court for the District of Columbia, in FTC and the people of New York versus Google and YouTube. And there's some very important things in here that will help clarify this issue, as it may or may not relate to individualized channel owners. The first thing to take note of is that in the definition sections, it makes a distinguishment between a channel owner and an operator. So first of all, channel owner means individual or entities who upload videos onto YouTube. That, for example, would be me. Uncivil Law, I'm an individual who uploaded videos onto YouTube service. You're an individual who uploaded videos onto YouTube service. You're a channel owner. I also like to take note here that as an owner, that presumably gives me some sort of ownership rights that even if YouTube themselves interfere with, means I could presumably sue YouTube for interfering with my ownership rights, but that's another issue for another day. Let's press on. A channel owner is distinguished in this settlement from an operator. An operator means any person who operates a website located on the internet or an online service and who collects personal information. So I would argue that I am not an operator. I do not operate a website located on the internet or an online service. I do not operate YouTube. I do not operate Google. I am not an operator. So I am not a person who operates a website located on the internet or online service, and I would suggest the very fact there's a definitional split between channel owner and operator means that channel owner and operator are two distinct things. Channel owners are not necessarily operators, and operators are not necessarily channel owners. They are distinct concepts. So you can be a channel owner and not an operator. And I would suggest that unless you are YouTube themselves, you are not an operator because you do not operate a website. The settlement goes on to say that the FTC is concerned about personal information that is collected or maintained on behalf of an operator. I, as an individual owner, do not collect or maintain any personal information. I do not operate YouTube. The settlement goes on to clarify that website or online service directed to children means a commercial website or online service or portion thereof that is targeted to children. I, as an individual owner, do not operate a commercial website or online service. I do not operate YouTube. And the FTC, in determining whether the website or online service is directed to children, the Commission will consider a whole bunch of stuff, which we've seen. But this only applies to websites or online services. The FTC goes on to clarify that websites or online services shall be deemed directed to children when it has actual knowledge. Individual channel owners are not website or online service operators. YouTube, as part of its settlement with the FTC, agreed to develop, implement, and maintain a system for channel owners to designate whether their content on YouTube service is directed to children. So the reason that YouTube is requiring you to do this is that YouTube, as part of their agreement with the FTC, agreed to do it. They agreed to maintain a system for channel owners to designate their content. But the statute actually doesn't apply to channel owners. It in its text applies to operators. And we've seen a definitional split in this very settlement between channel owners and operators. So although YouTube is required to develop, implement, and maintain a system for channel owners, the statute, FTC, does not actually have jurisdiction over channel owners. They only have jurisdiction over operators. But what does the law actually require? To answer that question, let's look at the actual law. This is 15 U.S.C. 6502. This is the Child Online Privacy Protection Act in its regulation of unfair and deceptive acts in connection with collection and use of personal information about children. So this is the actual act. And in looking at the act and trying to decide whether it applies to you, let's look at the actual definition sections and what it actually says. First of all, in acts prohibited, what is actually prohibited according to the law? According to the law, it says it is unlawful for an operator of a website or online service directed to children or any operator that has actual knowledge that's collecting personal information from a child to collect personal information. And you can see operator is underlined. This applies to operators. Well, what is an operator? Well, we can see the definition of operator here. Operator means any person who operates a website or online service and collects or maintains information. This is the same definition we saw in the settlement. That's where the language came from in the settlement. It came from the actual United States Code. So this is what an operator is. It is defined this way by Congress. So in determining whether or not you're liable under the statute for anything by the FTC, we look to what the statute actually says. And it applies to operators. Operators are persons who operate websites. And as we saw from the settlement, there is a separation in the definition section from a channel owner and an operator. Channel owner is someone who uploads video. Operator is this. These are two distinct things. I am not an operator. I do not operate any website or online service that collects information because I am not YouTube. So I don't think that this statute applies to me as a channel owner, despite what the FTC and YouTube have said. We can go on to see that separation through the rest of the statute as well. We can see how here in this section it talks about what is required of operators. We can see in this section how it talks about operators. We can see in this section how it talks about operators of websites or online services. Are any of you guys YouTube? How does this apply to us? Doesn't appear to on its text. We can also see this in the Code of Federal Regulations that furthers out this. This is 16 CFR 312.3, Regulation of Unfair Acts. This is the regulation that was actually passed by the FTC. And we can see what the FTC actually has said about it. And we can see in the CFR how it talks about operators of websites, operators that have actual knowledge. This is not talking about channel owners. It's talking about operators. So the statute does not seem to apply on its text to channel owners. It only applies to operators and YouTube. YouTube, of course, is free to reach any agreement it wants with the FTC, but I didn't sign an agreement with the FTC, so I don't see how anything YouTube said applies to me. So hopefully that was helpful in some way. Of course, I would be remiss if I did not note that the FTC has said that they can go after individual channel owners. They have said so in their own press conference. So a lot of what I'm saying is contradicted by what the FTC has said. So the question is, well, who's right? To answer that question, we can look at the relevant statutes. The FTC, like every federal agency, is governed by the statutes that governs it. The FTC cannot do more than the statute allows it to do. And we can look at how terms are defined in the statute. And we've read the relevant definitions. We've also seen how the settlement on its own terms separates the distinguishment between channel owners on the one hand and operators on the other hand. So although YouTube has said that certain channel owners must do certain things, when we look at the actual text of the actual COPPA law, the law as written does not talk about channel owners. It only talks about operators. And at least as far as I'm concerned, as it applies to my channel, I am not an operator. I am not YouTube. I am not Google. I am not running an internet or a website or service. It is YouTube who's doing these things. So even though the FTC has said they can come after me, I don't think they can. Now, again, I'd be remiss if I did not point out that I cannot give you individualized legal advice. So, does this apply to you as a channel owner? Well, I can't tell you whether or not it does because it would be remiss. I don't think it applies to me. I can give myself legal advice, but whether or not it applies to you, you should hire an attorney of your own. But we've looked at the relevant statutes, we've looked at the relevant regulations, we looked at the relevant settlement, we looked at the relevant definitions, and so you can form an intelligent opinion based on the way the statute is actually drafted. Are you held liable under COPPA? We've looked at what COPPA says. If you want to take another look at it yourself, it's 15 USC 6502. That's the definitional section, and it's 16 CFR 312.3. I'll put a link to both below so that you can read all these things yourself. I'll put a link to the settlement. I'll put a link to US Code. I'll put a link to the CFR so you can read all these things for yourself, so you can inform yourself as to what it says. But if you look at the actual way the law is written, it applies only to operators. And so whether or not you're an operator is something you have to decide for yourself. I don't believe I'm an operator. And with that, my friends, that is all for now. I hope you're well. See you later. Cheers and goodbye.